Soldiers of a broken world, with data banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet. Oligarchs with the greedy hands tight. Central banks stealing our nights light. New world order creeping in disguise. We see through a facade and all their lies. Burn all their lies. Break right through. Break right through. Rise up, soldiers of a broken world. With tattered banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet.
Good morning, everyone. I hope everyone is having an excellent morning. I literally just finished preparing for this stream. I'm actually glad that I have that song now. It gives people a chance to show up, and then also gives me a chance to finish pulling up various tabs and whatnot. I have an excellent show for you guys this morning. I was looking for a way to clarify what we were discussing, or rather what I was pontificating upon in the last stream, Philanthropaths, and in doing this research, actually it kind of clicked everything into place. With it is entirely centered around caring for the poor, and we're going to go through the entire history of it. So I listen to, and ordinarily I don't, but I listen to some other law podcasters just to see what they were talking about. And everybody has a piece of it, but they keep treating the birth certificate as a bond, which it's on bond paper, but it's actually a settlement certificate. Right? You could call it a bond, but it's not really a bond. It's a settlement certificate. It's an evidence that of a conveyance of your estate, meaning that you gave your estate in exchange for a benefit. And settlers are paupers. Okay, that's generally where settlements are done. Is with populations of poor people. That's what a settlement is basically like a work camp. I mean, not in every single case, but primarily. And the birth certificate is a settlement certificate. So in looking for a way to clarify this, I actually came across an article that ties all of so we're going to look at a WordPress this morning, which I told you, don't ever take a WordPress at face value, but I actually have all of the lawful documents to back up. And this person who put this piece of research together, which I'll link it once we start looking at it, they're exactly right. And this is exactly how this has happened, right? So how did they take us out of law and put us into equity, right? And we're going to go into the difference between law and equity a little bit more in Blackstone's commentaries, and exactly why it is a terrible thing to be in equity without the restriction of law. Okay, it's essentially tyranny. It's the will of whatever the judge's conscience happens to dictate, and that becomes law. It literally allows judges to legislate when you're in a pure equity jurisdiction. So But before I get to all that, it looks like either notifications are slow this morning, or so, or we have a little bit less of a crowd. But we've got the usual adorable, good to see you, DSN. I do not think I've seen you before, so you must be a new subscriber. Godheart Guardian, and then of course me commenting with several others watching. And over on the Rumble stream, it looks like we have a few over there as well. So I guess let's just get into it, because I don't have much time this morning and there's a lot of information to cover. Let's see here. We're going to start with this WordPress that I came across. And I think you guys will find this interesting. So this is about the origin of settlement certificates, which I kind of went into on the last show, Philanthropaths Part 1. But today we're going to really explore this, because I see DSN's been with us for a while. Silent listening. Well, glad to have you. Settlement certificate, also known as a birth certificate since 1837, is an official document issued to validly recorded poor paupers, granting them certain basic rights and entitlement to benefits. So we'll pop over here for a second just so you can see what settlement means. Settlement. So in a trust, you're either a grantor or a settler. Okay. There's a couple other names, but generally those are. And a settler conveys the estate for the benefit of some person or persons, right? So you could be a settler and not a pauper, but generally when you're settling something, it's for the benefit of someone else. And now paupers, they settle their estate for the benefit. So if you basically, it's welfare. It's what welfare has always been. Let's get back to the document, and then I'll give examples, because I have Michigan revised statutes where they did exactly what we're going to read here. So it's an official document issued to validly recorded paupers, granting them certain basic rights and entitlement to benefits in exchange for recognition of their status as being owned as property and lawful slaves, also known as indentured servants and bondsmen. A settlement, therefore, is the equivalent to a voluntary slave plantation. This is 100% correct. That's what we live in now, is a massive, all nations are just basically giant corporate tax plantations. That is actually the accurate definition of what society is today. They've taken away. So I'll give you guys a little historical and we'll get in. This is basically, if you were, so the way feudalism was set up, right? Common law deals with real property. Okay. Equity was created to deal with equitable rights resulting from a trust, a contract, a perpetual contract. So you could be a free man and live as a tenant on the estate of a lord, and you would pay rents, a certain amount of rents and profits to the lord, but you would be considered free as a peasant, and you generally had some trade to sustain yourself. You're a blacksmith or a farmer or something like that, and you pay rents to the lord, but you were considered free. You know what I mean? So you had access to the common law. Paupers have nothing. And so what they would do is they would settle their estates. They would be issued settlement certificates, what we're about to read. And the only thing they had in exchange for the benefits they were going to receive, which was basically the ability to work and have housing, if they're lucky, and some food and stuff like that, is their labor. The only thing they have to exchange is their labor. So basically the state, or the crown, back when it first started, would take control of their estate, give them some benefit from the estate, but they would basically find ways to profit from their labor. And this would take form in workhouses. And nowadays it takes the form of basically being able to borrow against your productive value, your future productive value, in the form of, creating a social security trust, something that you're projected to pay into over a period of time they can borrow against, and, various other trusts. And we'll get into that in a little bit. But this is how it originated. The birth certificate, I can't stress this enough, is a settlement certificate. So we got Splicer Bear showed up, Incarnate Unlimited, and LJ. Good to see you guys. So this is the origin of settlement certificates. Under King Henry VIII of England and his Venetian Magyar advisors, the first poor laws were promulgated around 1535, coinciding with the first official mandate requiring uniform record keeping by all all Church of England parishes of births, deaths, and marriages. Now, I have to add to this because the author doesn't put, even prior to 1535, the taking care, the maintenance of the poor was left to the church. That was the church's domain. Okay. So this is the first time it started to become regulated. And this is after the Protestant Reformation. So the kings and the bishops of the Church of England, all that stuff, they wanted to, or whatever you call them in the Church of England, they wanted to capitalize on the sweat equity that the church was previously capitalizing on. So it just changed hands from Catholic to Protestant, et cetera, et cetera. So anyways, the poor were considered the responsibility of the church prior to this as well, is what he doesn't say here, including ensuring they had ample work and did not starve to death, as they were considered by default the property of the church. It is still that way today. That is why all the judges wear black robes. That is actually what the entire jurisdiction of equity is. The entire jurisdiction of equity is ecclesiastical, and I will prove that. They desperately want to hide that, and I will prove that this morning, that the entire jurisdiction of equity is ecclesiastical, is a church jurisdiction. That's why the judges are under canons. Okay, that's what the judicial, the laws of the judiciary are actually canons. They're judicial canons. So, under Queen Elizabeth I of England, a set of measures which were introduced, which had the effect of accelerating the disenfranchisement of land peasants into landless paupers. Okay. So a set of measures which were introduced, which had the effect, that's written a little bit wrong, but he means a set of measures were introduced which had the effect of accelerating the disenfranchisement of land peasants into landless paupers. Under the Erection of Cottages Act, 1588, peasants required local parish permission to erect dwellings, whereas before the erection of a dwelling by a land peasant on their lord's land was considered a right. So they changed it from being a right, where these people could be freemen and hold tenements on the Lord's land and pay him a rent or a profit, right? They made it to where the peasants required permission from the local religious parish to erect a dwelling, and the parish would merely just deny permission and turn the peasants into landless paupers who now have to settle their estates and become, wards of the church, essentially. So, as a result, the ranks of the landless poor or paupers swelled. So I'm going to show you guys a couple, right? A couple things. So let me see here. Where was it at? So we have the administration of the poor. So look, if we pop over here, one of the ways that they've done this in the Republic was through immigration. And one of the ways that they're doing it, and they're trying to do it worldwide today, is immigration. Immigration, they're bringing in immigrants from third world countries who have nothing and are essentially landless paupers. Okay, well, they did this in Michigan. This is why Michigan has always been basically a colony of England and under this ecclesiastical law since its inception. Now, when it was a territory, you had some natural rights. But yes, exactly, Jeff. Jeff says rights of a freeman are greater than benefits of a slave. Yeah, because those benefits can be taken away if you don't do what the person giving them to you tells you. Rights are endowed upon you by God. They're unalienable, and they cannot be taken by anybody except for God unless you contract them away or you settle your estate because you're a pauper, right? So, anyways, so what Michigan did, and I always thought it's even the name Michigan, right? And there's a lot of German towns in Michigan. And so what Michigan did in its early days as a state is it brought in a lot of orphans and it brought in a lot of immigrants. And the reason they did that was so that they could do exactly this, create townships, right? Parishes and townships and communities of indentured paupers. So you'll look, let's see here, we'll go, that no person shall be deemed to gain a settlement in any township within this territory by virtue of any purchase of any estate or interest in such township, right? Whereof the consideration for such purchase shall not amount to the sum of $85 bona fide paid for any longer or further time than such person shall inhabit such an estate. So almost every single, they only ever talk about people who were settled here, that if any overseer of the poor of any township shall have any reason to believe that any stranger who shall have come to, well, here, before I get to that, look, let me go back here. So Under Charles II of England, the concept of settlements as plantations of working poor controlled by the Church of England was further refined through the Settlement Act of 1662 and the Poor Relief Act of 1662, including, for the first time, the issuance of settlement certificates equivalent to a birth certificate. That's what it is. It's a settlement certificate. Passport and Social Security rolled into one document. A child's birthplace was its place of settlement, unless its mother had a settlement certificate from another parish stating that the unborn child was included on the certificate. However, from the age of 7 upwards, the child could have been apprenticed and gained a settlement for itself through indentured service or voluntary slavery. Also, the child could have attained the settlement for itself by the time it was 16, right? So under the terms of the Settlement Act, this is where it gets crazy. Under the terms of the Settlement Act, no one was allowed to move from town to town without the appropriate settlement certificate. If a person entered a parish in which he or she did not have an official settlement, and this is all the way back in 1662, okay, and it seemed likely to become chargeable to the new parish, then an examination would be made by the justices or parish overseers. From this examination on oath, the justices would determine if that person had the means to sustain himself. The results of examination were documented in an examination paper, right? So check this out. We're going to go to this Michigan statute here. Right from, I forget when this one is, 18 some. We'll look at it after because I don't want to lose the page. Actually, is it in the side here? No? All right. Yeah, I'll look at what this is, like 18 something. Anyway, that if any overseer of the poor of any township shall have reason to believe that any stranger who shall have come to reside in such township and who shall not have obtained a legal settlement therein is likely to become chargeable to such township. It's literally just like this from the 1600s. If a person entered a parish in which he or she did not have an official settlement and seemed likely to become chargeable to the new parish, it's the same thing. They're using the poor laws to place everybody under indenture. That's what they did originally. Now, is likely to become chargeable to such township, such overseer shall apply to any 2 justices of the peace of such township, which is exactly what it said back here, right? It says that the examination would be made by the justices right here, or parish overseers. Same thing right here. It's likely to become chargeable. Such overseer shall apply to any 2 justices of the peace of such township or of the county in which such person shall live, and inform them thereof. And the said justices being so or otherwise informed or suspecting such stranger to be of insufficient ability or likely to become a charge to some township. So here's the whole thing. It's the creation of trusts that bring you into equity. And by making you a trustee of your own estate through settlement, they bar you from access to common law and put you in a permanent state of equity as a pauper under the overseers of the poor. And it's still that way. That's what they've just expanded it to everybody. Am I making this stuff make sense or what? What's going on, Ryan? 1778, Pegs, Dead and Drumming. Good to see you guys. So it's literally word for word right out of the Poor Acts and the Settlement Acts of the 1600s right here in Michigan in 1800. And it's the same thing, and see what happens. So we'll look at the definition of charge. Okay, what is charge? Oh, that's settlement. That's the conveyance of the estate. Charge I pulled up right. Yeah, bear with me. I do have it somewhere right here. So charge, the particular kind of commission which one undertakes to perform for another in keeping the custody of his goods, is called a charge, right? So they administer your estate. They give benefits from what they're able to produce from your labor. So you're unable to take care of yourself. They take control of your estate. And remember, an estate is everything that you have interest in, basically any property or land that you have interest in, right? So you don't necessarily have to own something for it to be part of your estate. You just have to have an interest in it. So say, for instance, you're a peasant on the land of a lord, and you have children, and you're a freeman, but you have what's called a tenement on the land of a lord that you can farm, and you pay him rents, a certain percentage of the crops. And then you die, your son by right inherits your tenement as part of your estate that gets passed down to your descendants. So everyone has an estate. When you become a pauper, or when you're taken as a pauper and you settle your estate, the state or the crown, depending on what country you're in, takes control of your estate because you cannot maintain or take care of yourself, and then finds a way to make money off of the productive value of your estate, which is why they created central banks, because they wanted to expand the settlement work plantation worldwide. And the only way to do that was by getting every country dependent on a central bank, and then bringing the taxpayers under the status of collateral for the loans given by that central bank. You see what I mean? And then that way, and then once they bankrupt the country, then they finalized and enacted the final part of their plan, which was to create debt notes or debt securities, debt contracts that are secured by the future labor productive value of the taxpayer, of the tax chattel, permanently placing them in the role of trustee of their own estates through settlement, right? And forever barring them from any rights to property or real property law called common law. And most importantly, and the reason why the attorney did this, was placing the attorney in the position of God, as we'll read here shortly. Okay, actually, we'll get to it right while we're hot on the conversation, right? We'll pop over to Blackstone's, right? So equity. Well, first, let's just show that equity always falls under, or trust always falls under equity. Okay, so let's do it in this order. They mortgaged the estates of all the United States 14th Amendment infant paupers, right, in order to secure the right of being able to engage in commerce and all that good shit. Well, first of all, when you became a 14th Amendment citizen, I hate having to repeat this every single time, but you basically gave up your sovereign status as one of the people in exchange for the protection of your rights. So you settled your estate to the United States Corporation in exchange for the protection of civil rights, which are equitable rights in your own estate. Because basically you're saying, I'm unable to protect my own rights. I need your protection, your help. I need you to take care of me, Daddy Government. Please take care of me and govern me harder. And they were like, okay, sure, no problem, little infant pauper. Just let us take control of your estate, and we'll protect your rights since you're unable to protect them yourself. And that is why the public debt shall never be questioned. Okay. Yes, exactly. Peaceful. So charge says, charge etymology is to load, to put a burden on, fill in with something, to be retained, from Old French. And that doesn't, because all this stuff comes from the French, from the Normans, from William the Conqueror, right? Well, it was introduced into Western law. So anyways, 1933, since they already had the estates of 14th Amendment infant paupers under administration for the infants' benefit, for the paupers' benefit, they were able to mortgage those estates. Don't believe me? It says the money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. What happens when something is mortgaged? We'll go over here. The party who borrows the money and gives the mortgage, the debtor, is the mortgager. The party who pays the money and receives the mortgage is the lender, is the mortgagee. Under early English and U.S. law, the mortgage was treated as a complete transfer of title from the borrower to the lender. The lender was entitled not only to payments of interest on the debt, but also the rents and profits of the real estate, created a trust. Now you become the trustee of whatever was mortgaged. You have the right of use for the benefit of the lender while the loan is outstanding. And guess what? This loan has no repayment date. So it's permanent indentured servitude. And it created a trust forever barring you from common law. We're going to get to that. This meant, as far as the borrower was concerned, the real estate was of no value, that is dead, until the debt was paid in full. Here's another Norman word, French word, right? Mort gage, dead pledge. That means that the real estate, and this is another reason why they wear black robes and you're civilit mortis, because it is your estate. Your body is a vessel. It's property of the estate. It's not your body. It belongs to the estate, and it has to be maintained in case the heir comes and claims it. It's been mortgaged for the benefit of the estate, to maintain the estate, right, which they're allowed to do. And therefore, everything belonging to the estate is considered dead to the law. Right? And any rights to it can only be accessed in a court of equity. So when something is mortgaged, it creates a trust. This is how they put you in the permanent position of trustee. You guys following me? Yes, I can link all these websites if you'd like. So here, we'll do this real quick. We'll put them in the chat. And then if I have the presence of mind to do it later, I'll put them in the description. Or if somebody comments and reminds me after the show, I'll put them in the description. This is a very good explanation with some typos, but like I said, WordPress you never take them at face value, but I'm showing you that this guy's actually right. Whoever wrote this, exactly a great way to explain what I was trying to explain on the last show. So this is the Michigan. I want to say this is 1838. It's at the top, and if I scroll to the top, it's going to take forever to load and stuff. But this is actually Michigan Revised Statutes. I want to say it's 1830 something. So it's in there. And there, we'll link that. Here's another one. No, the other one I think was 1827. This one is 1838. And this is, this one says the same type of stuff. It says, where did I read it? Shall have not gained a several senatives, shall be deemed as settled in such township. A minor may be emancipated from his or her father and may gain settlement. So it's like Michigan was dealing with settlement of the poor the entire time. And just like it says in this treatise over here, or this, not this treatise, this WordPress over here, giving you the history of what Queen Elizabeth did. Queen Elizabeth I says that she introduced, or I'm sorry, under Charles, the concept of settlements, or no, Queen Elizabeth right here says, which had the effect of accelerating the disenfranchisement of land peasants into landless paupers under the Erection of Cottages Act 1588. See, so what these people, these noblemen who came over here and settled this free republic where the people are the sovereignty and all that, had the intention the entire time of retaining the sovereignty for themselves. We're talking about the nobles, the barons, right? So yeah, in order to get everybody to fight the Revolutionary War and get them to not revolt against them right after, because you got a bunch of a whole population of battle-hardened veterans now, they had to let them be free. So the people, that's why for a short period of time, say like 20 to 30 years or so, we actually were free in this country. Apparently never in Michigan, but when Michigan was a territory, yes. And so you had the right to your property is what that means. And you could access the law of real property known as common law. But immediately through presumption, they started using courts of equity under probate, using the Magna Carta and all that to escheat or take the estates of the poor and who they considered insane and who they considered to be spendthrifts and who they considered to be all these things. And they took it under administration, right? Reducing their status of those people to trustees of their own estates. And then they could drag them into and deal with them only in equity. And when you read these old law books of Michigan, they only ever talk about chancery, which, just so you guys know, chancery is equity. So for the sake of when we see this in the future during this stream, I want to show you some. This is from 1701. This dictionary is from 1701. And I guess I got to pull it up, don't I? It's over here. Or 1708, I apologize. 1708. And it's going to be right here. So we're going to blow this up. Chancery. Can you guys see that? This is a 1708 dictionary. It's called Cowell Dictionary. It says Chancery is a court of equity and conscience. Now remember, Federal Rules of Procedure, Civil Procedure Rule 2, is one rule or one form of action. That's the civil action, meaning equity. Okay. Chancery is a court of equity and conscience, moderating the rigor of other courts that are not strictly tied to the letter of the law, whereof the Lord Chancellor of England is the chief judge, blah, 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 right? Well, it kind of took, we had chancellors in Michigan during the time I'm reading these treaties from. So we're going to go over to Blackstone and see what Blackstone says about equity. So let's go over here. So what is equity? Okay. Equity. It says that, so he gives an example of where equity was necessary, and basically it's to complement law, but law and equity are entirely different, which is why in all state constitutions and the federal constitution, you see a distinction made between law and equity. because equity is not law. As Blackstone, one of the most revered jurists in all of modern, well, relatively modern history, will tell you right here, he says, from this method of interpreting laws, by the reason of them arises what we call equity, which is thus defined by Grotius. The correction of that, wherein the law, by reason of its universality, is deficient. For since in laws all cases cannot be foreseen or expressed, it is necessary that, when the general decrees of the law come to be applied to particular cases, there should be somewhere a power vested of defining those circumstances. Because the law, common law, is cut and dry. Did this happen? Then this. That's it. There's no, oh, well, there's a mitigating circumstance, or, oh, this happened, or, oh, we think this person might do something, like an instance of drunk driving. We think that they might hurt somebody, so we should make it a crime to drive drunk, which I don't entirely disagree with, but I don't agree with pre-crime either. So it's one of those things where it's like, I see the benefit, but still, it's again, it's actually criminal to charge somebody for pre-crime. That's bullshit. And so we're going to treat this as if you did hurt somebody. And that can only ever happen in a court of equity. Okay. So it says, which had they foreseen, the legislator himself would have expressed. And so he says, equity, thus depending essentially upon the particular circumstances of each individual case, there can be no established rules and fixed precepts of equity laid down without destroying its very essence. Right. So you have maxims of equity, but equity is generally expressed now in statute and code, because that's all it is. But like right here, Blackstone says that you cannot establish fixed rules and precepts without destroying the essence of equity, because it's case by case. It's essentially the judge's conscience or the chancellor's conscience. And that's literally how chancery started. Remember, chancery and equity are interchangeable. Chancery started by the priests going, hey, let us hold your conscience because we see you're really busy, king. Right. And we can handle all these cases of trust, because this is, and I know I'm kind of going from place to place, but you have to follow me. Trust is only ever dealt with in equity. So what is equity? Equitable rights are when you have no real property rights, but you have an interest via contract or some other agreement that's created a trust. So you have equitable rights in something, and those rights can only be accessed in a court of equity, which is not a court of law, because a court of law would say you have no right to this property until you pay for it or until it's your property, right? So that's what equity is, right? So, so when your property is under administration and the courts tell you to use the government who's administering your property tells you to use it a certain way, they have to enforce that through courts of equity, which is why they took away common law. Because at common law, you could be like, how are you even administering my estate? Show me where I agreed to this, or show me, where the letters of administration were granted, under what presumption, and who attested to it, and et cetera, et cetera. Oh, they can't have that shit. So they don't even want you to know about it, which is why they're erasing all knowledge of common law, even though it's right in our constitutions. But they've made people so fucking stupid that you have no idea the reason that they say law and equity is because equity is not law. So what he says right here is you can't establish rules and fixed precepts of equity without destroying its very essence and reducing it to positive law. And, which is what they've done, they've reduced it to positive law. And on the other hand, which actually just allows them to legislate whatever the fuck they want, which is what he says here. And on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law, which is what the fucking attorney wanted to do from the start, and leave the decision of every question entirely in the breast of the judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law. That's how I feel too. Fuck equity. Get rid of it. Yes, dangerous freedom over peaceful slavery, Catch. Exactly. Good to see you this morning. And so, which would make every legislator, he says, equity without law would make every judge a legislator, which it has, and introduce the most infinite confusion. So a perfect example of this right now, even though it's all equity, but is all of the shit the court is doing, like against Doge, okay? Regardless of what you feel about Musk or any of that shit going on, they are showing this wasteful spending of the corporate tax chattel notes, or what we call money, right? They're generating this for beneficent purposes. Again, this all goes back to taking care of the poor, which is how they borrow the money in the first place. Against your sweat equity is for your benefit. And I guess it benefits you to promote transgenderism in third world countries, right? So all that shit they're finding that they're like, why are you spending millions of dollars on this? Well, now a judge introduced an injunction, or put an injunction against the executive order, which injunctions are a term in equity, which means to stop something before it happens. That's what injunction means. And it can only happen in equity. You can't deal with the future at law, right? And now the judge is doing that because why? Because his wife receives U.S. aid money, right? And he can do that, just like Blackstone says, is because it makes every judge a legislator. Now you can just be like, oh, stop doing that. Why? Because I'm losing money. What? But he can do it, and now they have to stop. That's what equity is. Welcome to equity, guys. That's equity. The judge can just is king. All judges are kings under equity. Fuck them, right? Let me try not. Hold on. Woosah. Let me not get too pissed off this morning. Let me keep my thoughts in a cohesive and see, I'm all discombobulated. Let's calm down. Okay. So as there would be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. And that's a fact, right? So when you're placed in a trust, which you are, because a mortgage creates a trust, right? Or even just the settlement, which is what happened before the 14th Amendment citizen and all that shit happened in Michigan, right? It creates a trust. Let's pop over to a handbook, not a handbook. What is it? A practical treatise on the law of trusts. Now, this is an amazing book. I just came across this morning, read the preface or introduction, and I downloaded it, but I kept it on the archive so I could give it to you guys. You guys need to read this. Is fantastic. If you have questions about it, email me or ask me during the show. What have you. So this is the origin of trust. Now there's a lot of devious history here, and that's why I wanted to get to this morning. A lot of devious history here, because this is how first equity was created as a result of trust, as we're about to read. But trusts themselves were created out of fraud, or the desire to commit fraud, which shouldn't be surprising. And corporations are trusts. So the concept of corporation was created by the concept of a trust. Now let's read about the origin of trust, shall we? The origin of trust. You guys need me to zoom in on that a little bit, maybe? Hold on. Whoops, wrong window. Let's click this one. Okay. The origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. By the interposition of a trustee, the debtor thought to withdraw his property, and interposition basically means like by the intercession or acting as an obstacle. Interposition would be like, think of it, interposition, placing yourself in between one person and another, or this thing and that thing, interposition. By the interposition of a trustee, the debtor thought to withdraw his property out of the reach of his creditor. So when somebody owed money, they would create a trust and give the property that they wanted to protect to the management of a trustee, right? And therefore, it was out of that person's possession and the debtor couldn't touch it. So fraud. The freeholder to intercept the fruits of tenure from the lord of whom the lands were held, right? Same concept. And the body ecclesiastic, meaning the church, to evade the restrictions directed against the growing wealth of the church by the statutes of mortmain. See what happened, and I believe it was during the reign of King Edward I. What happened was people were leaving their lands to the church. Now, what's the problem with that? Well, the problem is the church has no descendants and the church doesn't die. The church has successors. So once the church inherits land, or the church gets control of land, the church never lets go of the land. So if people in England keep giving their land to the church, and King Edward accurately saw this, and he was like, oh, hell no, eventually what's going to happen is the church is going to own the majority, if not all, of the land, because it never dies. It holds it in perpetuity. And when the Pope dies or whoever dies, then a successor arises, right, is appointed, and it just keeps going. So that's where the Statute of Mortmain came from, or the Statutes of Mortmain. And so another inducement to the adoption of the new system was the natural anxiety of mankind to acquire that free power of alienation, means to be able to convey your property, to sell your property. To alienate it is to dispose of it, essentially, or to give it to somebody, whatever you want to do. It all means the same thing. And the settlement of their estates, the alienation and settlement of their estates, which those are just two different words and different forms of conveying your estate, which, as we've seen, what settlement is to convey for a benefit, right? Which by the narrow policy of the common law, they had hitherto been prevented from exercising. Originally, and I know this stuff might be boring, but you guys have to learn this stuff if you want to be free. I'm dead serious. So if you tune in, you're like, oh, he's using too many big words. I'm sorry. There's just nothing. I can't make it. I'm trying to explain it. You know what I mean? So I can't make it any more simple. And you have to understand these concepts like settlement and alienation, for instance, right? So that actually brings us to this is where attorneys come from, is a torn, right? A torn in feudal law to turn or transfer homage and service from one lord to another. This is the act of feudatories, vassals, and or tenants upon the alienation of the estate. So in order to convey the estate, right, an attorney was necessary to convey it from one lord to another. That's what happens right now with the judge in the United States. That's what's happening. You need an attorney to transfer homage and service, to allow the court to be able to take a portion of property, being you, from the estate that has been settled because you're a pauper, and to create a new constructive trust, and which is also called a pass-through entity, and use that trust to generate securities, just like the government does, and just like the utility companies do, and just like everybody else does in this big scheme of tax chattel securities farming. That's what I call is securities farming, right? So, the judge needs that service to be transferred by the attorney. It needs to be attorned over to the judge so the judge can take it and create a bond. And they take power of what? Attorney over you to sign the bond on your behalf in the first place. And then they can securitize the bond, meaning they can sell it, cash in on it. So that's what's going on. It's called securities farming. That's what I call it. I don't think anybody's ever, I've never heard anybody but me call it that. I'm not saying I came up with it, but I did come up with it for myself. So, and for this show, and it's securities farming. So back to the treaties. Originally, so here we go. Originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee. So what that means is that say that an estate's been settled to the church, and this is really what the attorney that wrote this is saying without saying it, right? Because by the time this treatise was written, like in Michigan, and they were already doing a bunch of this with the settling and the making entire counties of paupers, and taking all the estates under administration, and then you only have a few wealthy, powerful barons of Michigan, which we still have today, controlling everything. Now, in fact, the feudal lords are corporations. That's what we have in this country. The feudal lords are corporations. So what they're saying is that and this is, he's going to bring up a bishop as an example. So remember when I said the poor were the problem of the church, basically, not the problem, but they were under the jurisdiction of the church. We'll just say that, right? So when the poor were the jurisdiction of the church, obviously their job was to make sure that they had enough work to sustain themselves and that they weren't burdensome on society. So of course the church would take their estates would be settled to the church, and the church would thereby find a way to profit from their productive value, and then give a portion called a benefit. You never want to be the beneficiary, called a benefit to the trustee, because now the person who settled their estate with the church because they were poor, couldn't take care of themselves, they now become a trustee of their own estate. That's what's happened to you. Okay. Now they're a trustee of their own estate. Now, what he's saying is originally when this started going on and the concept of trust was introduced and all that stuff, and they're like, oh yeah, okay, we're going to make this person a trustee. He's got to manage the estate for the benefit of himself and the church. And he has to use it the way that we tell him to, because he can't take care of himself. That's why he's here in the first place. And obviously they found ways. So this is what created workhouses and all sorts of just heinous shit. This is why they started orphaning children, to basically create big armies of pauper indentured workers for these businesses and corporations. And it's insidious when you really get into the history of this shit, right? But originally, when it started, he says what this term means. Originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee, meaning it was the honor of the trust. There was no security put up. The trustee didn't have to have any kind of security, right? Any kind of surety for his faithful execution, right? So think when you're in court now, right? The judge creates the constructive trust. You're now the trustee. And what are you required to put up for your the faithful execution of the obligations of the trust? A bond. He creates the bond. He gets the bond on his own. He signs on your behalf, but now you have to also indemnify him for the bond. So you have to either put up the equivalent value in Federal Reserve notes, or you have to sit your ass in jail as surety for the bond he created. Okay? So, but the mere feeling of honor, proving, as was likely when opposed to self-interest, and extremely precarious security. So that's what he's saying. He's saying, yeah, honor wasn't good enough. So John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena, by which the trustee was liable to be summoned into chancery and compellable to answer upon oath the allegations of his set to K trust. That's what happens when you get summoned to court. You are being summoned into modern day chancery, right, to be compelled to answer upon oath allegations of any kind of violation of your set to K, because as a 14th Amendment infant pauper, you are the set to K. You are the set to K. The estate is the set to K. You represent the estate. You are the property of the state that they seek to create trusts out of. You're the set to K, the living trust. You're not one of we the people. You're a living trust because your property's been mortgaged, which creates a trust. The lender has the right to the fruits of the land that has been mortgaged. That would be you. And you are the set to K. So you will use your property, infant, not your property. You'll use, if you're John House of Doe, you're the trustee of the John Doe estate, and the John Doe estate is not yours because you never claimed it. And you, as far as the law is concerned, you're John Doe. You're not John House of Doe. You're John Doe, right? And that estate, you're the estate, though. That's what it means. And now you need to maintain even your body in case John House of Doe happens to come and claim his estate. But right now, he's presumed missing or dead. And that's what the word decedent means. So when you look on these IRS tax forms and all this stuff, you'll see decedent estate or decedent this, or when you look into like the uniform disposition of unclaimed property or any of that type of stuff, they refer to the debtor and the decedent. The decedent means pending death. So they're not saying that you're dead, but you're not alive because you never claimed to be. So they're basically saying, I don't know. That's what decedent means, pending death. Means I don't know. And it allows them to take your property. So anyway, so they created this writ of subpoena, which is now summons. They don't call it subpoena anymore. They just straight up call it summons. And they're summoning this dead creature, this ens legis, creature of law, into the court of equity now, even though it says chancery. Remember, that's court of equity now. And compelling you to answer for your violation of the trust. Oh, you were driving 60 in a 55? Is that what you were doing? Well, you violated the terms of the trust. And now we're going to fine and fee you. Oh, you didn't pay for permission to use the trust, right? You don't have your slave plate on the back of your car and all that, so we're going to fine and fee you because you're misusing the property. So, and that's the whole thing. So thus, in the words of the old counselor, the parents of the trust were fraud and fear, and a court of conscience was the nurse. This guy, this lawyer in this book right here is telling you this, that the whole concept of trust was built upon the desire to commit fraud by the attorney. That's it. Benefits include prison. That's exactly right. It's not prison, it's corrections. Remember, because it's got to be a benefit. It's got to be a benefit. It's called a compelled benefit. That's why they call it corrections. Infant pauper needs correction. So we're going to appropriate money that from the mortgage of his estate. We're going to appropriate some money and send it over to corrections. And of course, we're going to have to pay a warden $100,000 a year. And we're going to have to pay all the worst people, human beings on the planet called corrections officers, sizable salaries and overtime to correct the infant. Yeah, that's the whole name of the game, guys. See what I mean? So good morning, make people stupid people famous. Good to see you. So of trust, there were two kinds. Now, I haven't even read this far yet, right? The simple trust and the special trust. Now, when they use the term special trust, it means special. Okay? Special. So let's see here. The simple trust, which also passed by the name of use, was defined in legal phraseology to be a confidence not issuing out of land, but as a thing collateral annexed in privity to the estate of the land and to the person touching the land, right? The set decay use should take the profit, and that the terra tenant should execute an estate as he should direct, right? So basically what this means, annexed in privity, is by two people. Privity means that two people have interest in the same property, right? So to the person touching the land, I'm not sure what that term silicet, but that set decay use should take the profit, and that the terra tenant, meaning the tenant of the land, should execute an estate as he should direct, meaning the set decay use, the person using the set decay. Okay. So this is the whole thing, is that you are the trustee of a set decay trust, and you are to use it for the benefit of the lenders. So let's go back to this. Let's go back to this WordPress and see what else I can correlate to actual lawful documents and congressional record or treatise of law, right? Because this is a great collection of exactly how they're doing it. Right. So you have to remember, you have no access to any kind of lawful money. In the 70s, we became insolvent. You are at law. You are dead to the law. You have no access to it because you have no access to real property, and you have no access to the ability to acquire real property by using lawful money, which is gold and silver. So they are trying to permanently lock you into the position of an indentured pauper who's dead to the law and under courts of equity forever, especially if they get the digital currency off the ground. You will be locked into the courts of private conscience where the judge is God forever. And these judges are the furthest thing from God. They are the most satanic, evil, greedy pieces of shit that have ever existed. Even John Bouvier, who was an attorney, knew this. If we go, so I want to show you guys. So courts of chancery or courts of equity give the judge what's called discretion. Now, discretion may not be a big word to you right now in common parlance, but discretion is huge. So when we go down to discretion, a little bit further, dishonor, discretion, right here. When it is said that something is left to the discretion of a judge, this is why Blackstone warns against abandoning law for equity. It signifies that he ought to decide according to the rules of equity and the nature of circumstances. And then right here under number 2, the discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. It is casual and depends upon constitution, temper, and passion. In the best of judges, it means it is oftentimes caprice. In the worst, it is every vice, folly, and passion to which human nature is liable. That's insane. And now you see the prima facie evidence of why the attorney wanted to destroy, or they can't ever destroy common law, because that is what law is. There is no other kind of law. That's anytime you see just law written in any kind of founding document, they mean common law, right? But why the attorney wanted to bar you from accessing common law, because the attorney is satanic and wants to become God. That's why. There's no other reason. Like, we can go again, and I know I've done this quite a bit, but we'll go to the Michigan Judicature Act, right, which I have saved. And we'll search the favorites bar. We'll go Michigan Judicature. And so it's 1914, the year after the Federal Reserve. Oops. Oh, yeah, that's right. It's in my files. Duh. Sorry about that, guys. I don't know why I looked on my favorites. Michigan Judicature. Bear with me. So this is going to be 1914, right after the Federal Reserve was established. And remember, since before Michigan was established, it was hard at work ensuring the settlement, which means conveyance for a benefit of estates, bringing in a bunch of immigrants who were forced to settle their estates because they had nothing when they came over here, and basically taking control of the entire state through chancery, and essentially having but very few wealthy private people that could access common law. That was Michigan's intention the entire time, because the people who founded the state are a bunch of scumbags. All right. And I don't need to know them to know that, because I see how they set up the state, and I see the way they set it up, and they're fucking scumbags. And so right here at the beginning of this Michigan Judicature Act of 1914, it says right here, the matter of the here, I'll bring it to the top since I can't highlight it. It's right where it says 1. The matter of the abolition of the common law forms of action has been the subject of a great deal of debate throughout the country for many years, of course, because you scumbag attorneys who were originally barred by the original 13th Amendment that was stood as a ratified amendment to the federal Constitution for over 20 years. But then the attorney finally got enough foothold in the country and said, oh, well, there's been states added to the Union since then, and they didn't get to ratify, which doesn't fucking matter, because they signed up to the Constitution as it then existed, which included the original 13th Amendment. And we'll actually get to the original 13th Amendment, because it forbids them from holding any office of trust or profit. And what an office of profit is created by the settlement of pauper estates. And I'll prove that with Pennsylvania's original Constitution in just a moment, if I remember. So we recommend the abolition of all such forms of actions, meaning common law, except the actions of assumpsit, trespass on the case, replevin, which they've definitely tried it. Well, they can't get rid of any of it, because we're the ones who create the court. The court is the sovereign and his suite, or his suit, which is you. You can hold court anywhere. You file action against somebody who has wronged you, and in a common law court, there's only a magistrate. And the magistrate is merely a referee, because it's a court of record. And in a court of record, the tribunal is separate from the magistrate, meaning the adjudicating authority, being a jury, and if there is no jury, then it's you as the sovereign. That's how common law works, because common law, just like England, common law, the sovereign is the authority. And who is the sovereign? The king. So what'd you have? The king's bench. Well, guess what? We don't have a king. We're the sovereigns. That's how it works here. It's how it has worked. They never want you to know that, but that is how it works. You hold the court. This is why citizens can arrest. This is why people can arrest other people. If you witness them doing a crime, 2 or more people witness somebody committing a crime, they can arrest them, take them. But you also, and this includes even if you're arrested by an officer, you're supposed to be taken before a magistrate immediately. Never supposed to be taken to jail. That's for another show. Right? You have to take them to a magistrate and attest and sign an affidavit of what you witnessed. And there has to be a victim. But again, I'm digressing. So it has not seemed to us practicable to go so very far in matters of substance in abolishing the distinction between legal and equitable proceedings, right? We propose that actions that have been brought on the wrong side of the court may be transferred to the right side and be proceeded with instead of being dismissed, thus rendering the beginning of a new action unnecessary, right? But what is equity? Doesn't deal with law. Equity can deal with certain aspects of law, but the law is the law and equity is equity. And equity is essentially what I like to define the enforcement of private law, meaning it can only enforce something that has been contracted to or agreed upon between two or more parties. It becomes the enforcement of private law. That's why trusts always come under equity. Now, before I get to the Pennsylvania Constitution, there was one more thing I wanted to show you guys. Yeah, look, they're changing the names of everything. This proposal is in line with the new federal equity rule 22. Remember what Blackstone said about equity. If you're just now tuning in, go back earlier in the episode after the show is over, because I'll constantly be going in a circle if I keep going back. But we propose the abolition of the designation register and chancery, and that the county clerk shall be the clerk of the circuit court at law and in chancery. So they literally abolished the distinctions between the two jurisdictions just to confuse you, simply just to confuse you, right? So that the process for appearance in equity cases shall be designated a chancery summons instead of a chancery subpoena. See, that right there is actually where they changed from subpoena, which we seen created right here in a practical treatise on the law of trust. Holy shit, how did it go all the way? Okay. Yeah, right here where they talk about Bishop John Waltham originated the writ of subpoena by which the trustee was liable to be summoned into chancery and compellable to answer upon oath the allegations of his set decay trust. Did you violate the trust? Right? What have you been doing? Essentially, right? So, and that's the whole thing. When you go to court on a traffic ticket, you are being summoned into a court of chancery to answer for your role as a trustee in the violation of the trust. There's no crime. So people always wonder, what? I didn't hurt anybody. Why am I being dragged into court for it? Because it's not a court. It's an administrative hearing because you're a pauper under settlement. That's what your birth certificate is, a settlement certificate. Okay, your estate has been settled, right? It has been settled to the state, which has then been pledged to the United States, which then was mortgaged to the fucking Federal Reserve or the DTCC, right? And is now held in trust. Well, it has been held in trust the entire time, but now it's got liens against it, and those liens carry obligations, right? And one of those obligations is registering all of your property because it's part of the collateral. And now you're in one big workhouse, and that's what you pay taxes for and all that stuff. And they hold an office of profit over you. What's the difference? So a bond is a written obligation. So the difference between a bond is a written obligation. The trust itself is, well, the bond creates a trust. Yeah. So the bond. So like right now, I know, Val, you're on a bond probation is what we'll call it, because it's ridiculous. It's pretrial probation, which they can only do through a bond, right? So your bond conditions. Like, so you have this situation where you committed a breach of trust, you know, the DUI or whatever, you committed a breach of trust. So they drag you in, they say, okay, you've been summoned into this court of chancery, which is now called equity. You've been summoned or subpoenaed, same thing, but they just keep changing the names. It's basically an ens legis, a dead entity, and we're calling you in here to answer for this breach of trust. Right now, they feel because you have no rights as an indentured infant pauper whose estate is under administration, they feel they have enough evidence to hold you. So now there's this breach of trust matter, right? And so now the property needs to be bonded. The case needs to be bonded and insured, right? Because again, it's all the administration of the estate. So they always need to protect the property of the estate in case the heir comes and claims it, which would be you as one of the people, but you've never done that, which is what we teach in the class on Friday nights. So the bond they create, so the bond is basically a written obligation, and in the bond they get crafty and they're like, okay, and as part of your bond, so you're gonna have to pay this value of the bond, right? You're going to have to indemnify us, which really you're just indemnifying yourself, but I don't want to confuse people. And that's why they take power of attorney over you and sign the bond for you, because you're really just indemnifying yourself. But you're indemnifying the court, which you are an employee of. And as part of that indemnification, right, they have certain stipulations that they can get you to agree to. And the alternative that will act as a surety for the case would be you sitting in jail. So they basically give you the option, put up X amount of performance notes and or Federal Reserve notes and adhere to this certain set of stipulations, or sit in jail. Either way, each one guarantees your appearance for them. And that's how they get you on pretrial probation. So the bond created a trust. Now you're a trustee performing the obligations of the bond, which is drug testing and whatever else they have you doing, going to see a counselor, which they, of course, this is how they generate more securities off of the original bond. Now they get to contract. Okay, part of the bond is you got to go to substance abuse counseling. So now they have a contract with the substance abuse counseling company or whatever that has a contract with them. And of course they have their little kickbacks within there and all that stuff. Right. And then you have the drug testing agency that has a contract. And so this is how it's a multi-billion-dollar prison industrial complex. And remember, it's not prison, it's corrections, by the way. It's correction. They're correcting you, Val. They're correcting you. So do you feel corrected? You naughty, naughty infant. So where was I going with all this stuff? Shit. Yeah. See, I hate when I get sidetracked like that, but I did want to answer that question. So what time are we at, guys? 8:43? Well, damn. Yeah, I think I got to shut it down, actually. I'm sorry, guys, as we've been going about a little over an hour, and I've been going to bed too late. I apologize if I'm leaving you hanging. Do you guys have any questions before I get off here? Go ahead and type them in the chat. I would correct them myself. I know you would. They're fiery Russian. I got you. Do you guys have any questions before I let me check the Rumble side? Let's see. Oh, okay. There's Ryan's over there. I guess I'll probably pick up on this part 3 when I do my next morning show, because there's a lot to get into. But here's the bottom line: is they've taken administration of your estate through presumptive. Okay, I'm going to put it in a clear, concise way to finish this off, right? So everybody has an understanding of what I'm talking about you being an infant pauper. So there was never a federal citizen until 1868, when the 14th Amendment was ratified. Well, was said to be ratified, but it wasn't ratified. And even in Andrew Johnson's veto message, or Black's Law 4th edition, Black's Law 6th edition, says the 14th Amendment created, or at least recognized for the first time, the concept of a federal citizen, because there was no class of citizen called United States citizen. That was referring to a citizen of the District of Columbia. Anytime before that, when they said United States citizen, they meant a citizen of one of the several states. And I can prove that, have proved that, and Black's Law proves that by saying it created or recognized for the first time the concept of a United States citizen. And that's also evidenced in the very first line, where it says all citizens. Well, here, we'll take a look at it. Whoops. Because why not? Before I get off here, 14th Amendment. 14th Amendment. We just want to look at the 14th Amendment. So here we go. Constitution, annotated, it's okay, whatever. So all persons, so notice how it doesn't say people, all persons born or naturalized in the United States and subject to the jurisdiction thereof, right, are subject or are citizens of the United States and of the state wherein they reside. See, and that word subject is important, because you're not subject to either your state or the United States, most definitely not. So it created a dual citizen. Okay, but in order to become a citizen, you had to come under the United States jurisdiction, which means you had to naturalize with them. So I can show you guys an example here. Why not, since we're here? McDonald v. State, Indiana Supreme Court. All right, this is from 1883, so shortly after the 14th Amendment. And I'll explain the whole thing. I have explained it at other times, so we're just going to get to the point. So it says that although he was not a citizen of the United States, he was a citizen and voter of the state under Section 2, Article 2 of the state constitution. One may be a citizen of a state and yet not a citizen of the United States. And that's Thomason v. State, Corey v. Carter. So the 14th Amendment, even though the 14th Amendment was unlawfully ratified, they still had not gotten everybody under United States jurisdiction. But those who came under United States jurisdiction, this is the benefit they accepted: that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the law. See, people already had that right. And it was up to the people to secure that right. So here, the federal corporation stepped in and said, here, infant, I'll protect your rights if you agree to come under me as essentially a trustee. Right. So this is where this would be a form of settlement of the estate. Right. By accepting that benefit, beneficium abstinendae, he who accepts the benefit abstains from being the heir. By accepting that benefit, you were reduced in status to a chattel. And that's literally what it was. So they said this was for the newly freed slaves, but even Andrew Johnson in his veto message said they don't need that. They can learn to be free, right? The only reason that they were not free people is because they were not freeholders. They weren't able to sustain themselves, just like we've been talking about this entire time. And that actually, I'm glad that we brought this up, because we'll pop over here to the Pennsylvania Constitution real quick. So this is the plan or frame for the government of the Commonwealth or state of Pennsylvania. And notice how it says Commonwealth or state of Pennsylvania. I'll get into that at another time, but that is important. So Section 36 is what is important. As every free man to preserve his independence, if without a sufficient estate, meaning if your estate doesn't sustain you on its own, right? Your property, meaning if your property doesn't generate income, ought to have some profession, calling, trade, or farm whereby he may honestly subsist. There can be no necessity for nor use in establishing offices of profit. Now, when you actually look for the definition of offices of profit, it is very difficult to find. And you can actually only find the definition by looking at Supreme Court cases or by finding out what it is distinguished from, which would be an office of honor. But essentially, the office of profit is like the administrative office, is an administrative office where you're administrating, like overseers of the poor would be an office of profit. Okay. And that's because they get to take the settlement of the pauper estates. The estates are conveyed to the overseers of the poor, and then they get to figure out a way to make their productive value profitable for both them and the benefit of the poor. And that's where they came up with the concept of workhouses or leasing these people out to plantations, stuff like that. Because essentially, once you come under what they're talking about, they're saying they don't want to have to establish offices of profit. So they're saying every free man, and this is in 1776, they're saying, so every free man needs to have some profession, calling, trade, or farm whereby you can honestly subsist. And then we have no necessity for establishing offices of profit. See, this was set up at a time when they knew how the whole system of indenture was set up in the first place, right? And then you contrast this with Michigan, where their entire intention was to set up offices of profit. They wanted as many poor and indentured people as they possibly could, so they could take their estates and profit off of their productive value. Come here, pauper. Come here. I got a workhouse you can work in, and you can keep, a portion of it, and I'm going to keep the rest. And I'm going to make sure you're taken care of, because you wouldn't be at that workhouse if it wasn't for me. And I'm going to make sure you work. And you know what? Since you're under me and I'm administering your estate, you can't do this with your body. You need to be in your house by this time. You can't you can't do any work on Sunday. I mean, there's literally statutes which can only be done in equity, forbidding people from doing things on Sunday in Michigan and these old statutes. So it's insane. But this is my point. Right. So they're literally he says the usual effects of which are dependence and servility unbecoming of free men, in the possessors and expectants, meaning in the people who hold the office and the paupers, right? Faction, contention, corruption, and disorder among the people. But if any man is called into public service to the prejudice of his private affairs, he has the right to reasonable compensation. And whenever an office, through increase of fees or otherwise, becomes so profitable as to occasion many to apply for it, the profits ought to be lessened by the legislature. See, they're fighting against the corruption that Michigan embraced wholeheartedly with their overseers of the poor. You guys see what I'm saying? So, Catch, what are you talking about? Can some do special or qualified endorsements after declaring executor like a ticket for? No, you don't want to do it. So what you're listening to other people, and this is kind of what I was explaining at the beginning, is where people think they can play in the sandbox. And so if you go and you endorse the ticket because you're like, oh, well, I'm the creditor and the 14th Amendment citizen's the debtor or whatever, so I'm just going to endorse the ticket as the creditor and then turn it into the treasury. It's defeating the whole point, because then you're accepting a benefit. That's the whole point, is that they want you cannot discharge these tickets and stuff like that without being the beneficiary. And if you are the beneficiary, then you're not the heir or the executor. I mean, technically, you could be an executor and beneficiary, but you're not the heir, because that's one of the ancient maxims of law, is beneficium abstinende. He who accepts the benefit abstains from being the heir. So by having the treasury discharge these obligations, right, what you have to do is you have to remove their jurisdiction. You take the sand out of the sandbox, and there is no obligation. Like, what do I have a ticket for? My property's not under administration, right? So there is no reason to wait. You're fining and feeing me. Remember, you're summoned into chancery to answer under oath or affirmation for the Set Decay Trust. That's the only reason you're summoned. But if you are the executor, the heir and the executor of your estate, there is no trust to answer for, because what you're doing is you're removing the estate from their administration. And once the titles exist within the same person, the equitable and the legal title exist within the same person, the trust collapses. So there can be no trust to enforce for them. That's the point. Do you kind of? Yeah, Brandon Joe Williams is a perfect example of somebody who thinks they can play in the sandbox. I'm not knocking him if that's what he wants to do, but here's the thing. So like I spent this whole show explaining that in a court of equity, the judge is God. In a court of law, which you have access to once you're the heir and executor of your estate, and you have the access to the law of real property, which is the other name for common law, there is no judge. There's no judge. And you are the sovereign. So then you can take that person maladministrating your estate as executor dishonor, right, which is a crime, pretending to be a judge, and you can file a counterclaim against him and serve him with your paperwork and sue him. And that's how it works. That's how there's a $6,800,000 lien on the judge in Colorado and 3 other officers. So if you're going to be in the court of equity, the judge literally can do whatever he wants. That's what Blackstone said. That's what Bouvier said. He says the discretion of the judge is law of tyrants. And in equity, that's what equity is the discretion of the judge according to equitable maxims and principles. Right? But then you have to trust that he's going to adhere and not, like Bouvier said, fall victim to every kind of vice and folly or capriciousness known to man, which is what judges do, which is why they wanted to set up this situation in the first place. But I'd be more than happy to do a show with Brandon for sure. Because before you can even talk about UCC, you have to talk about how you got the UCC. What is UCC? Right? They mortgaged your estate. That's what all the securities are issued off of. They mortgaged your estate, which created a trust. And then they've created other trusts off that trust. They generate securities upon securities upon securities. That's what the entire scheme of UCC is. What I say is you just take the foundation out from under it. Why would you even fuck with it? And on top of that, you're never going to get the Treasury to discharge your bills. They're supposed to. You're absolutely right. But see, the issue is that you, in order to get them to discharge your bills, you have to be one of the people. And if you're one of the people, right, then you can't be in their courts answering for a violation of trust, because if you're one of the people, but you let them continue to administer your estate, then you're not the heir and you're not one of the people. You are the 14th Amendment. So you cannot be both, is what I'm trying to explain. You cannot be both. It's impossible. So if I'm so the whole thing about settling your estate and being taken under administration, like we read right here in Michigan, where they're talking about any overseer of the poor of any township, if somebody moves in and they've what was it? And they haven't obtained a settlement, which means conveyance, because we'll go here. Settlement is the conveyance of an estate for the benefit of some person or persons, right? So this is for poor people or for people who cannot manage the affairs of their estate. So if you're one of the people and you're saying, no, this is my estate, I'm one of the people and I'm the creditor and this and that, and they're going to say, well, then why are we dealing with your estate? What are you talking about? If you're one of the people, then none of that applies. So it's like it's your name. It's a catch-22, right? It's your screen name. I know your real name, but it's your screen name. So it's a catch-22, man. Does that make sense or no? Your estate is already in an ecclesiastical trust. That's the whole point. It's so the overseers of the poor and courts of equity have always been an ecclesiastical jurisdiction. That's the whole. That's like what, if you're tuning in just now, Theo. That's the whole everything I went through today on today's stream. Yes. So this when you settle your estate as a poor person, right, to receive a benefit, that's where I was at over here with the 14th Amendment, right? So you're receiving a benefit and you're coming under their administration. And now you've become a subclass of citizen as a 14th Amendment citizen, which is an infant pauper, because Title I, Section 8 defines all. So you must necessarily be an infant if you cannot see how it says privileges and immunities of the citizens of the United States. You don't have rights. You have privileges. Privileges, not rights. So now you have privileges, which are benefits. If you actually look up privileges, there's essentially benefits granted by some kind of superior sovereign power, which is not, the United States doesn't have its own inherent sovereignty, but it has basically third-hand sovereignty from the people to the states to the United States. And so now it's granting the subclass of citizen privileges, right? And therefore they get to take control of your estate. Now, for the benefit and privilege of the infant, they can sell any portion of your estate or they can mortgage the whole thing entirely. And what is your estate? Is your interest in property. It's your property rights, okay, which they clearly did right here. It's because it's backed by the credit of the nation. It represents a mortgage on all the homes and other property of all the people in the nation. So they mortgage your estate. Why did they do this? Why did they create the 14th Amendment? Because Section 4, the validity of the public debt of the United States shall not be questioned. That's why they did it. So they could rack up a bunch of fucking debt against your sweat equity and your productive value and then make you indenture for it. Because they're a bunch of greedy inbred scumbags. So, okay, well, I'm glad at least you understand. We can discuss more. Why don't you come up on the panel Friday night, dude? I haven't even seen you in there Friday night. Is something going on Friday night or something? Come up on the panel and we can have a discussion about it. And it's much easier than just reading your comments and then trying to guess what you're saying. But yeah, that is the point. So With that, I think I kind of rounded it off there. Now, especially since the United States, you signed up to basically be personnel of a corporation. We're just going to put it simply. It's not technically, I mean, it is technically one of the many layers of contractual obligation, but and that corporation is bankrupt. You see what I mean? So now you're a pauper by proxy. If the whole corporation is bankrupt and this is basically who you settled your estate with and who you have taken care of you because you can't take care of yourself, you need privileges instead of rights, then you by proxy are also bankrupt, which makes you dead to the law and by definition a pauper. So for your privilege and benefit to be able to continue to engage in commercial activity, they mortgaged your estate. And that's how you ended up in this situation. But see, they were already busy doing that before they even came up with the idea of making it throughout the entire union. You see these northern states that are primarily manufacturing centered were already busy taking the estates of the poor so that they could fill their factories. That's why Michigan is a big factory state, big manufacturing state. And that's why everybody's so encultured into being paupers and not taking care of themselves. I mean, it is fucking sickening almost. It's bad. It's bad. You have multi-generational tax chatteling in the blood up here, in the blood. It's maybe because half my blood comes from down south. I don't feel that way. But I mean, these people love being tax chattel, a lot of them. It's disgusting. And on top of that, the people who set this state up are absolute scumbags, for sure. Greedy scumbags. These are empire building barons is what they are at the expense of everyone else. And the main way, and the last thing I'm going to say, the main way that they do this is they bring in immigrants. That's why Michigan had so many immigrants. This explains the orphan trains, okay? Because orphans, by virtue of being an orphan, they come under administration. They're paupers. They require settlement and apprenticeship or whatever they call it now or during this time. But originally, as we were reading in the Elizabethan times and stuff, it was apprenticeship. And they would get settlement certificates and go learn to work. And then eventually they created workhouses and there were deplorable conditions. And of course, they loved to have orphans because the orphans needed to work and didn't have anybody to take care of them. So at all these orphan trains that everybody wonders about, and they're like, Great Reset and all this stuff or whatever. Or it could just be this simple. Maybe they did engineer something to kill off the majority of freeholders and then replace them with orphan paupers that they could then administer their estates. I mean, that would be one huge explanation but I can guarantee you this, everything all comes back to the law. And them wanting to remove you from common law and place you into equity where the fucking bar pirate can be God. That's been the main point the whole time. So with that, I will see the Jurist Society, my fellow Jurist Society members, Friday night. And I will see the rest of you possibly Saturday night, but more than likely Monday morning. So thank you guys for joining me this morning. I hope you enjoyed the presentation. I know it seems to be, all over the place, but all of this stuff is interrelated. And if somebody reminds me, I'll probably remember, but just in case I don't, it's not put up in timely fashion, somebody remind me to link a lot of these documents into the description of the show for future viewers. And if you are a future viewer, just comment and remind me if it's not there, and I will get to it because I'm pretty good about responding to all that stuff. So anyways, you guys have an excellent day, and I will see you next week, more than likely. And Jurist Society, I'll see you guys Friday night. Have a good day.